This panel is going to address that question of whether the employee says, I don't want to work on my Sabbath, which, by the way, could be Friday, Saturday, or Sunday, depending on who you are. What has to be done about that in light of the recent Supreme Court decision? And I'd highly recommend the paper that was done on this subject, which is in your materials. It is very good. And on our panel right now, we have Marjorie Mesidor, right? Is that correct?
Yeah.
Who represents employee interests. Professor David Sherwin from the Cornell Hospitality Program, Professor of Labor Relations there. And Zoe Salzman from the prominent civil rights firm Emory. And they're going to address what we do with all these religious employees. And their discussion is going to be followed by a commentary by Professor Estreicher and a prominent former public official here in New York, Rory Lantzman. And they're going to just have a short discussion after this program. Take it away.
Thanks for the introduction, Terry, and nice to see all of you. Hopefully, while you munch on your cookies and drink your coffee, we can bring you up to speed on recent developments in religious accommodation law. As most of you know, and if you've been at the conference so far, you've heard mention of, the Supreme Court decided a case last June called Groff versus DeJoy, which, according to Justice Alito, who authored the opinion, merely clarified the Hardison decision that had been the law since 1977, and according to everybody else, blew this world wide open. So we're going to give you, starting with Marjorie, an overview of the Hardison decision and the law up and until the Groff decision. Then Dave is going to tell us about Groff, the facts and the holding. And then we're all going to have a discussion about some of the implications that flow from that decision and how they're beginning to play out in some cases. And in particular, we're going to talk about a really interesting case coming out of the Seventh Circuit, Klug versus Brownsburg Community School District, which is a fascinating discussion about a school policy on how to handle transgender students' preferred names and a teacher who voiced religious objections to that policy. So Marjorie, to start, tell us about the law before June of 2023. What was the standard and how were courts interpreting it?
So before June of 2023, when courts were looking at cases involving religious discrimination, what the employer would need to prove is what they would call above a de minimis standard, right? It had to be more of a de minimis burden on the employer to accommodate this particular religious practice, whether it was vis-a-vis a day off or religious garb, whichever way the religious accommodation request manifested itself. And it was, I would say, a fairly low standard to show that it just needed to be above de minimis. And then when Groff happened, it shifted. And now they have to show a substantial burden in terms of cost, as well as impact on the business or the business of the organization in order for an employer to in any way say that the religious accommodation request is unduly burdensome.
Great summary to get us started. So just to remind us all for a minute, can you or Dave give us just a brief overview of Hardison? What was that case about and how did it lead to the de minimis standard that we all thought was the law until last year?
So real quickly on Hardison. So Hardison was a Jehovah's Witness who became observant while he was already working at TWA. Because of seniority, it was unionized. Because of seniority, where he was working, he didn't have to work on weekends. He moved from building 1 to 2 or 2 to 1, and now he was the low person on the seniority list. And so for about 10 weekends, 10 Saturdays a year, he would have to work on his Sabbath. And so he came up with several proposals to accommodate his religious belief. One was to have a supervisor do his job, and that's unit work. Now he can't do that. Another was to overcome the seniority system and let him just bump somebody, and no, that's the seniority system can't do that. Another one was, okay, I'll work 4 days that week, get somebody else to work overtime. You would have paid me time, so it's just half. And so that half time for about 10 Saturdays was what kind of was, that was his winner. It took a really long time for several of my coworkers and I, or co-authors and I, to find it, but it would have been about $150 a year for TWA. And at that time, a round-trip ticket New York to LA was like $175. So it's under one ticket. And the Supreme Court said, no, that's too much. And that's where the de minimis came from. So that was the $150 sent TWA over the edge. And so that gave us our standard. Is that covered, Zoe?
That covers it. So back in 1977, the cost of overtime at $150 per year, and the costs imposed on other employees who had their seniority rights that couldn't be bumped, that was more than a de minimis burden, and therefore TWA did not have to accommodate Mr. Hardison's requests for Sabbath observance and religious accommodation. Let's fast forward to 2023, to the Groff case. Groff was employed by the U.S. Postal Service, and when he began working for them, they did not deliver on Sundays, which was a day that Mr. Groff asserted he needed to observe the Sabbath on. But as many of us know and probably benefit from, U.S. Postal Service then contracted with Amazon to begin delivering on Sundays. And Mr. Groff was fired when he refused to work on Sundays. So tell us, Dave, about the Groff holding and what the Supreme Court told us about the de minimis standard.
Okay, a couple of things before that, but so first, both Terry and Zoe said they read my article, and so I want to say thank you, because that makes two people who have read it, so that's really cool. So that's number one. But substantively, there was, I would argue, and feel free to disagree, we had kind of a nice balance going if you looked at the ADA, and David's sitting in front of me, so I'll see what he says. If you looked at the ADA accommodations and Title VII religious accommodations, it's really difficult to be protected under the ADA. There's some work out there that says 65% of the ADA plaintiffs in summary judgment motions are found not to be protected. They're either not disabled or they're not able to do the essential functions of the job. But once you are protected, the employer has to do a lot. The accommodations can be substantial under the ADA. And then the counter on that with religion was we had two standards too. Are you protected under the religious standard, and what's the accommodation? Really easy to be protected under religion. All you need is a sincerely held belief.
And just to pause you on that for a second, Dave, and just unpack that for a second, Marjorie, I don't know if you want to comment on how the courts interpreted a sincerely held belief and what the courts interpret a religion to be.
Well, it may be shocking or maybe not so shocking to find that what is even considered a religious belief need not even include a deity or a traditional religion, or it could be a set of values or morals that overarchingly go around ideas of life, death, how you live your life, what you wear and what you eat. And it need not be prescribed to a formal religion. It need not even be prescribed, if it is part of a formal religion, it need not even be something that people who generally follow the religion follow. You could be the one person in that one traditional religion that does not follow this one religious accommodation, and it would still be considered a religious belief. For it to be considered a closely held religious belief, they say that it is a fact-by-fact basis. The standard for it is extremely low. The court has specifically said it does not want the court to start weighing what is a sincerely held religious belief or not, which is great and terrifying all at the same time. So
So just,
that part of the analysis was fairly easy to arrive at.
Yeah, right on. And if you go back to the beginnings where, as you said, you're exactly right. It doesn't have to be a top 5 or a top 55 religion. And if you look at where the case is, it's really out of people trying to get out of the Vietnam draft. And so it's the conscientious objector standard, sincerely held belief. And they just put that over and that's your quote religion.
Right.
I started to do a study that never went anywhere, and I was looking at religious accommodations with operations versus appearance, which doesn't really matter right now. But what I did was I coded a whole bunch of cases, about 120 religious accommodation cases from about a decade ago, and compare and contrast that with the 65% of the ADA plaintiffs who are not protected. When we did these, and this was all of our Lexis search was in this time period, all of the religious accommodation cases. There were north of 100 cases. There was not one where the employee was found not to be protected, meaning that they don't have religion. So again, that box is so easy to check. But then the employer's obligation was barely anything, and there was your trade-off. Then Groff shows up.
right.
And I just can't resist this. So, Alito told us that our reading for all these years was upside down. Sorry. And told us that when the court said de minimis in the last part of the case where it says we hereby hold that anything more than a de minimis cost is an undue hardship, the court didn't really mean that. And you got to go back 2 or 3 pages before where they talk about the term substantial costs. And so the new standard is substantial costs, that the employer has to prove that whatever accommodation will have substantial costs. And they didn't, of course, they'll never give guidance. So there's no guidance on what constitutes a substantial cost. But what we do know is that employee morale or fairness is not a cost. So if you've got a situation where one person needs to leave early because it's their Sabbath and they need to get home, and somebody else needs to leave early because they want to watch their child perform in something, or their child care provider has to leave or something like that, the fact that you must say yes to the religion, and that seems really unfair to the person who wants to be a good parent or whatever, that's not a cost. And morale is not a cost. That's just a bummer. And that's kind of where we are on, setting it up.
So let's unpack that a little bit. So the Supreme Court in Groff said, as David just summarized for us, that undue hardship is shown when a burden is substantial in the overall context of an employer's business. And the opinion emphasized that this was a fact-specific inquiry that would differ from case to case and depend on the nature of that particular employer's business, including the size and operating costs of the employer's business. So let's talk about that. Is the Supreme Court telling us that there are different standards in terms of when an accommodation has to be granted or not, depending on how big and perhaps how profitable the employer is?
I don't think there's any way around it, and so, and then the question is how big, how profitable, and where, which back to, and they kept saying it's fact specific, so, we are providing you with no guidance. So just, whatever you do, who knows?
So Justice Alito did say that the Hardison, he calculated the Hardison math to be, it would have cost TWA $600 per year to grant Mr. Hardison's request to force overtime on others to accommodate his Sabbath, which Justice Alito said was roughly $5,000 per year today, $5,000 per year today. And he said that's considerably more than de minimis. Is $5,000 per year a substantial cost for a company like a major airline post-Groff? I'm asking the easy questions today.
Right. In a billion years, how can you argue that $5,000 to TWA? Well, I always love the fact that you got TWA in Hardison and Thurston but not in existence. So, probably not a good use of your resources. But besides that, for a major airline, $5,000, there's no way you can argue that's substantial. I guess you could argue it if you did some sort of survey of all your religiously observant employees and found that there were 1,000 of them at 5,000 each, then maybe you could make that argument.
Right. I would tend to agree with that.
And I think in Hardison, another factor the court considered, and I think the Groff opinion cited favorably, was the fact that it was an indefinite accommodation, right? It would be 5,000 per year forever, right? It wasn't like they just had to do it once. It was going on and on and on and on. So I suppose there might also be an argument there. How many employees are going to be impacted, and how long does the cost have to be borne? But the Groff court was very clear that temporary costs, voluntary shift swapping, occasional shift swapping, or administrative costs are not undue hardship. So they told us some things that are out for consideration. But again, exactly how much those costs have to be, how long they have to be borne before they constitute undue burden. I agree with Marjorie and Dave. There is very little guidance at this point. Let me ask this question. Another point the Groff court was very clear about is that a coworker's dislike or animosity towards a religious practice or expression was not undue hardship. So an employer could not refuse to grant an accommodation because other employees wouldn't like it. Thoughts about what the court meant by that and how we might see that start to play out?
I think that a couple of different things. When it comes to things like religious garb and dietary practices, it's a little bit easier because the impact on others is de minimis.
To coin a phrase.
Right. But then when you start talking about religious accommodation that has to do with days off, and if the court had left it open that they could use things like morale or coworker animosity as an undue burden, then I think you also open up the door for hate. I think you open up the door for things like anti-Semitism, anti-Muslim, anti-whatever, deity period, when people start to say, well, I don't like it because, why can't I do it too? Maybe I should convert, and then you enter those kinds of discussions which could easily lock in the employer into other traps of liability, so to speak, if they went down that road. With that being said, I think that, and I know we haven't gotten into it yet, after Groff, when they started to look at Klug, and they started to look at the non-pecuniary cost of the substantial cost of allowing a religious accommodation, it really does make the analysis that much harder to have some clear guidelines of what is permissible and what is not permissible. And that's the part that becomes incredibly frustrating.
Yeah, and I agree with you on it's a mess if you're including morale, but it's kind of a mess if you don't, because it's like now you're saying somebody can leave, and Michael and I were talking before. If we both lived in Chicago for a while. In December, it's dark at 4:30. So if you want to be home before sundown, you're leaving at 3:00. It's kind of a good gig. And so now, if people are going to look around and say, well, wait a second, why does that person leave? It's like summer Fridays in the winter. I'll do that. And maybe I'll find religion is my way of being able to see this event or visit my, visit my parents, whatever it is. Mm-hmm. So, I think that on both sides, it's a problem by saying we're not going to include morale, or we're going to include morale, it's going to be a mess. Everyone's going to hate each other. But if we don't include morale, we're going to get people who are going to be silently angry.
So let's shift to the Kluge case, and if anyone knows how to properly pronounce
Yes.
that, please tell us. It's Klug or Kluge, I'm not sure, it's spelled Kluge. This is a case that came out of the Southern District of Indiana, and pre-Groff, under the Hardison standard, The school district had won on summary judgment that it did not have to provide the accommodations sought. The Seventh Circuit affirmed that decision, but before its mandate had gone back down to the district court, Groff came down, and the Seventh Circuit sua sponte reversed itself and remanded for the district court to reconsider the entire summary judgment motion in light of the Groff decision. So a quick overview of the facts there. This school district had enacted a policy that teachers were required to address students by the name listed in PowerSchool, the school's database of students. And students could change their name to their preferred name in PowerSchool if they had a letter from their parent and a medical provider supporting them in doing that. Mr. Klug was a teacher, a music teacher in the school, in the high school, and he claimed it was against his religion to use names that were not associated with students' birth sex. He said that was promoting transgenderism, he viewed that as a sin, and he said he could not do that. He asked as an accommodation to be allowed to address all students by their last names only. Initially, the school district granted his accommodation request, and then they rescinded it because they had received complaints from students, parents, and other teachers that this was offensive to transgender students, that it was causing harm to them and disrupting the learning environment. So, post-Groff, about 3 weeks ago now, the district court decided summary judgment again with a really thoughtful decision unpacking the Groff case. Does one of you want to tell us what the holding was? We'll start with the good part, and then we'll discuss some of the court's reasoning.
First, it indicated that it would have been a substantial harm for the school district to permit the accommodation that the teacher was asking for by calling all of the students by the last name. And what it used to arrive at that conclusion as it relates to substantial harm, and this is where the emphasis is placed not on a substantial harm related to actual cost of money, but substantial harm to the students and the business of the school. So they took a lot of guidance, I should say, from the school's motto, its mission, to have an inclusive educational environment where people would feel, welcomed and thrived, et cetera, and be able to thrive, et cetera. And that by ignoring a student's request to be referred to by their chosen pronoun or name, they were causing substantial harm as it relates to that level of inclusivity. And in addition, to throw in the pecuniary interest as well, they said that you were also possibly opening the district up to liability. Because by the district allowing the teacher to do it, then it becomes an act of the district, and then the student can say that the district itself is discriminating against them, and then we have additional legal cases and litigation.
Do you want to chime in, Dave?
I mean, the only thing, it's kind of more broad, but it's a question that says somebody sincerely held belief as it applies to how they interact with others. Mm-hmm. How can we legislate that? How can we require employers to allow an employee to interact with other people, how those people don't want to be interacted with? And the person said, well, it's my religion, so I get to call you this or treat you this way. I mean, the kind of opening or the slippery slope is really terrifying. Right. And if you think about what is religious freedom, I mean, at least as I learned it, it was freedom to practice your own religion, freedom to practice no religion and not to believe in any religion. Mm-hmm. And I didn't hear it was to impose your religion on others. I kind of missed that line. Right. And that's what this is seemingly saying. I mean, this case, if I think we're all agreeing, we're like, nice job, court, by saying that that this was a problem. But if another court, and you could see it easily, could say that's not a substantial cost. There was no money, and we don't see those lawsuits coming, and so on. And now this person, this teacher, can now declare that because of his religion, he can now call people by whatever name he wants. That just seems kind of bizarre.
So interestingly, the Klug decision, the teacher had also moved for summary judgment, and the district court found there was a material issue of fact that she could not resolve on the summary judgment stage as to the sincerity of his religious belief. The school district had put forth evidence that on occasion he did comply with the policy, suggesting that he was capable of complying with it if he wanted to, and that the Book of Church Order, which I believe is a religious text associated with his religion, spoke of allowing transgender students to use the bathroom of their choice. And the school district was basically challenging the sincerity of his religious belief. And the district court said, that's not something I, as a court, can resolve at the summary judgment stage. That would be a jury issue because it really largely comes down to a credibility finding as to whether you believe him when he says that's his sincere religious belief. So a question for you both. In the wake of Groff, do you think we're going to see more questioning of the sincerity of religious beliefs along these lines, allowing perhaps a jury to weigh in on the idea that it's a sincere or sincerely held religious belief?
I mean, well, I'm going to take a step back. There was a case here in New York where a man who's Muslim was a banquet server at the Waldorf, and the Waldorf required their banquet servers to be clean-shaven. He said it was part of his religion that he wear facial hair, and he got fired, he sued, and he showed up in court clean-shaven. And they did not find that he didn't have a sincerely held belief. Because they didn't bother.
Yeah.
And they just said, but, facial hair in the food, blah, 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 and it would be, it was an undue hardship. So the 50 years of not questioning your religious belief, it was a throwaway. Yeah, fine, that's your religion, but we don't have to accommodate you. And now that we have substantial costs, I absolutely think that, one, employers who didn't bother fighting it because you knew you were going to win on the undue hardship, so why do you want to go and fight somebody's religion? That just doesn't seem like a great idea.
Right.
But now they're going to have to. And courts who didn't want to deal with it are now going to have to deal with it because of what you said before.
Right.
If people are going to make up religion because it's a good way to get out of work early, then, you're going to have to now question their religion.
Right. I mean, we're attorneys, we can argue anything, right? So on the one hand, there is something to be said to a closely held belief or value that you should not have to justify to anyone except who you decide to serve or not serve, right? There's something about that even as I say it, right, I want to stand up and say the Pledge of Allegiance right after, that you just hold on to that religious freedom, right? This is why the original people came over to the U.S., on the Mayflower. It was in search of this religious freedom. So it is something that is very close to us as a culture and the way that our law is developed. We hope that it is the anomaly and not the norm that people are making up religions so that they can get out of work and other things, because we all, at some fundamental level, at least respect each other to decide that we can decide for ourselves. With that being said, I don't know how these cases are not systemically going to be before juries to be able to go through that analysis if that truly is the only factor that is left in play. I think that the fact that both the substantial harm is a case-by-case analysis, and they've only given you a handful of things that you should be checking off and looking at, and the fact that a closely held belief has, at least I can't think of a single circumstance where it's not been considered a religion or a closely held belief, that you're going to have a lot more cases going to trial. With that being said, Klug or Klug is not one of them.
But going with the COVID vaccine cases,
Right.
are and just this is just the worst for for all the management side lawyers who in 2020 told their clients, yeah, it's fine, you can require them to get vaccines because saying no, it would have more than a de minimis effect on the business. So don't worry about it, go ahead. Oh, wow, the law changed, but it didn't really change, so we're now applying it retroactively. So that advice was given under one law, and now it'll be tried under another law. And so the advice is problematic, or maybe, well, you know, now you're going to have to prove up that this has substantial costs. But so when you're there, there's no way you're not going to argue sincerely held belief.
Right.
And, you know, there's so much going on there. You're going to have a whole bunch of people who've been vaccinated their whole lives who got a sincerely held belief yesterday, and now they didn't want the COVID vaccine. And that's going to be litigated over and over again, and it's going to be nasty.
Right.
But I don't see a way around it.
So interestingly, on that issue, both the Kluge Court and also the Second Circuit, in a case decided after Groff at the end of last year, have, as Marjorie mentioned, considered the employer's exposure to potential legal liability as grounds to establish undue hardship and deny an accommodation. The Second Circuit case did involve COVID vaccine requirements, someone asking for a religious accommodation to be exempt from the vaccine requirement, and the Second Circuit held that it would have required the employer to violate a New York State Department of Health mandate to grant that accommodation, and the risk of liability that imposed on the employer was an undue hardship, even post-Groff. That was also the result reached by Kluge. As Marjorie mentioned, the district court there found the risk that the school district could be sued under Title IX or other laws that protect the rights of transgender students was sufficient to establish an undue hardship and deny the teacher's requested accommodation. So this may be another area where we see courts, you know, developing the case law in the wake of Groff to consider the threat of liability under other laws. You know, if you think about religious rights conflicting with, in this case, the rights of transgender students, we could think of an example of, you know, an employee who says they won't work with women because their religion says women shouldn't work outside the home, right? What is an employer supposed to do with an employee like that? So I think, you know, the Kluge decision and also the Second Circuit decision, which was another one I can't pronounce, but Dacuna versus Northwell Health System, decided at the end of 2023, you know, the courts are looking ahead to conflicts between different rights under Title VII for religious belief, but also other rights that are protected by Title VII or other laws. So I think there's going to be more and more analysis of that. And you've done some thinking about that, Dave, I know.
Well, but I'm just thinking, as you're saying that, and I agree with you completely, but then, and I think that the lower courts will try to figure it out and try to do, you know, something that makes sense. But then we go back to 303 Creative. 303 Creative says that your religion is now, you know, that beats Colorado anti-discrimination law.
Right.
So if, you know, if you own a business and you don't have to, or if you think you're going to do websites for weddings and you think somebody who's gay might come in, then you're allowed to sue and win now. So, you know, even that statute, the Supreme Court said they didn't care.
Yeah.
And so, you know, I would see it right, you know, the Second Circuit, which was great, but if it makes it back up, I'm not confident.
Can I raise the prerogative of asking one final question of Professor Sherwin?
Sure.
About an industry you're very familiar with. So for the Hyatts or the Hiltons or the Marriotts, if an employee says, I don't work on the Sabbath in your 24/7 business, I don't have to, right?
I think that, well, you know, 13 months ago, you would just say, wow, that's great. There's probably another industry that's waiting for you, but not this one. Now, I just don't know, and that's it. And so somebody comes in and says, you know, you're 100% right. We operate 24/7, and so, you know, whether it's, you know, front desk, housekeeper, or whatever, and you say this is what we do. I have no idea what the answer is, and that's what kind of terrifies me.
Okay, thanks. That's a good way
On
to
that
end.
note,